Lisa. I'm so happy to have you back.
So happy to be here, Julia, and so great to see you. I always miss seeing you.
I know. I love this.
It's
I love our
great.
chats. So I really want to talk to you about this case that came down in New York. Prenup case, JM versus GV. The Judge Sunshine. I love that name.
It's a great name, especially for matrimonial judges.
Yes, I know. Judge Sunshine upheld the prenup with the exception of the alimony clause or spousal support, spousal maintenance, as you call it in New York.
Yes.
What are your thoughts on this?
So I had a lot of thoughts about this case. I love this case, first of all, for so many reasons. So it was interesting. For years, I have said that you need to have all of the calculations in the maintenance portion of a waiver. And so in a prenup, many times people waive maintenance, not always, but they may waive maintenance / spousal support, which is support that you would get at the end of a marriage and could go on for a very long time or a short time, depending, and could depend upon the amount, etc. But essentially, you can waive maintenance in an agreement, but you also have to make sure that you followed all the rules in constructing the agreement. And what I always get pushback from my adversary on when we're doing a prenup is, well, you don't really need those calculations. They're not necessary. It's a prenup. We're not doing a divorce. And I have said in my office that everyone must have those calculations. So in other words, there are certain statutory calculations that go up to $228,000 of income. And there's a lot of different ways that you have to deal with it. But essentially, you need to have your income, the other person's income. I always like to attach the last filed tax return to the prenuptial agreement if you can. And then we go through the components of the calculation and we determine what the maintenance or spousal support would be had they not waived out of the spousal support. And then we even go one step further, which I don't think Judge Sunshine necessarily touched on in this, which is the reason why they are deviating from the statute. So if they're waiving out of maintenance, they are likely going to be deviating out of the statute if one party makes a lot less income than the other party. And it's so important to me to put those deviations.
What are the reasons?
So the reasons could be the other financial components of the agreement. It could be that someone actually can have imputed income, which we could talk about what is imputed income. It could be consideration for other things in the prenuptial agreement. Perhaps they're getting a large payout for equitable distribution. Perhaps they're getting to keep all of their assets or income during the marriage. There are a slew of things that, could be the reason for the waiver. Or frankly, it could be that one party is not willing to get married if they have to pay spousal support in the future. And that is a reason that people actually, decide that they're not going to get married. This may be a second marriage or even a third marriage for someone, and they don't want to have to actually be paying spousal support again in their lives. So I think these deviations are really important, this deviation language to have. Judge Sunshine really didn't touch on that, but he did touch on the calculations and that nobody could make a waiver of the spousal support if they didn't have the income of the other person. And that was what was so important to him.
And let's dive in because obviously the spousal maintenance piece is such a big part of this case and is why we're talking about it. So help us understand how spousal maintenance works in New York. How is it calculated? How does it differ from child support? What should couples be thinking about when entering into a prenuptial agreement?
So they should be thinking about a couple of things. One is the actual calculation. The second is all the factors that go along with spousal support. So there's a statutory calculation, which, as I said, goes up to $228,000 of income. Okay, that's not the end of the story. There are various factors that the court will look at in terms of spousal support to determine if someone actually should go above and beyond the income cap of $228,000. So, for example, the age and the health of the parties. Did the parties have a joint household before the marriage, actually, which would make it a longer time period that you would have been together with this particular person? Was there a sacrifice by one party in terms of education, training for work, career, etc., that they gave up in order to support the other person's career? Lifestyle is a huge component of it. What was your lifestyle? What did it look like? I mean, there are people who have lifestyles that are huge, and there are people who have lifestyles that they're big savers, perhaps, or they just can't afford big lifestyles. So they definitely look at lifestyles. Was there a stepchild in the house, or perhaps a disabled parent that someone was taking care of? These are all, there's about 15 factors that are looked upon, but I think that those are some of the most important factors that we look at, and whether someone is going to need time to get up to speed, to ramp up in order to earn. And that is really, I would say, the reasons that the court will go above and beyond the component, and obviously the income of each of the parties. That's such a big component. What is the income of each of the parties? If someone is making significant income and you have lived a significant lifestyle, then your spousal support is likely to be more. Then you look also at the duration of the marriage, and that is a key component, because that is going to essentially inform how many years of spousal support are you going to possibly get. And we also, in our prenuptial agreements, list those percentages so that people know, 0 to 15 years, they could get this particular percentage. After a certain amount, they could get 50% of the length of the marriage in terms of duration of spousal support. So this is really important, to look at the duration of the marriage in terms of this.
So what should couples be considering when they're entering into a prenuptial agreement and they're deciding, do I waive spousal support? Do I not waive? Do I contract to a certain number for the future? I mean, there's so many variables and so much can change.
So it's very complex, right? Spousal support, I think, is one of the most, I would say, difficult parts of an agreement, because you don't know, right, what somebody is going to be earning later. And you also don't know necessarily if you are going to have children, and if there's going to be a stay-at-home parent. And if there is going to be a stay-at-home parent, then what are you going to do essentially for that stay-at-home parent to compensate for the fact that they're going to be out of the workforce for a period of time, or perhaps
Sure.
a very long period of time. So there's a couple of things we do. If there's a stay-at-home parent, then we actually will compensate the stay-at-home parent sometimes, and we'll say something like, in the event that there is a child born of the marriage, including an adopted child, then there may be a certain amount per year that that parent is going to get. Or there may be a lump sum payout that that person is going to get if they're not working. And perhaps even if they are working, because they may not be able to work a full-time position if they're really caring for the child. But we essentially try to build in, when we speak to our clients, we also try to find out what's the plan. Now, look, everybody doesn't know what the plan is.
We don't have a
going
crystal
to
ball.
be.
Yeah.
There's no crystal ball. But there's some people who come to me and they say, we definitely want children, and this is an important topic for us, and I want to be a stay-at-home mom, or a parent who says, I want the other parent to be a stay-at-home parent, whether it be mom or dad. So it is an important topic, and we try to actually deal with that particular topic, and we try to imagine what will happen and to cover it. Now, if you didn't cover it, you could always go back and get a postnuptial agreement in New York. So you have to think about that also. So you might have waived, and now you have a child, and now you're a stay-at-home parent, and perhaps you even have a child who might have some special needs or special challenges, and you really need to have a stay-at-home parent. Well, that's the time to maybe go out and talk about a postnuptial agreement with your spouse.
So, Lisa, I want to go through some of the story around this case. So, wife proposed the prenup. She had some, I think, family inheritance. I think she also owned some properties with her sister. I believe per the decision I read, she made about $150,000, and her soon-to-be husband was a photographer, and I think he made very little income, and at one point, no income. And so it was her idea to get the prenup. She is the one who hired the family law attorney to draft the agreement, and he chose not to have an attorney. They entered into the prenup, meaning they signed it and notarized it 7 days before their wedding. And again, like I said, wife was represented by counsel. Husband chose to be self-represented, which, as we know, becomes an issue later in the case. And the prenuptial agreement includes the waiver of spousal maintenance, which is the central issue here. In terms of the divorce proceedings, husband challenged the validity of the prenuptial agreement and especially the spousal maintenance waiver. And he claimed duress, lack of counsel, overreaching, and asserting that he signed this agreement under pressure and without understanding of the implications. And we're going to talk about that as well. And one of the things I thought that was so interesting is Judge Sunshine specifically said lack of legal representation isn't enough, in that husband's decision to proceed without an attorney did not automatically invalidate the agreement. And he had been explicitly advised in the agreement that he could retain counsel, but chose not to. Judge Sunshine also stated, and we'll go back to all of this, there was no duress or overreaching proven. In his belief that the wedding would be canceled if he didn't sign was simply not enough to be duress. In that the bolded terms, there was something about bolded terms by the wife's attorney that he said amounted to some unfairness because given these bolded terms, the attorney was trying to, communicate something to him. And also, and this is the central issue of this case, was that for a self-represented spouse to validly waive spousal maintenance, they must be provided with the presumptive maintenance calculation under New York law. And this is exactly what you were just describing. So I want to go into that a little bit more as well. But let's first discuss the duress issue, because I think there is a misconception oftentimes about what duress means. People think, I'm getting married in a day or 7 days or even a month. And my partner is saying to me, if you don't sign this agreement, we're not getting married. Well, that is not duress. The definition of duress is effectively fear of maybe your life or your family's life, someone putting a gun to your head, threatening to kill your whole family. I mean, it's a really dramatic example, but how would you describe duress?
Well, I think that that's right. It's some sort of harm, some sort of threat to you that is harmful either physically or emotionally.
Yeah.
But the fact is that you have a choice. And your choice, if someone is saying to you, if you don't sign the prenuptial agreement, then I'm not going to marry you, well, that's your choice. And that's not duress. The fact is, you don't have to sign the prenuptial agreement. You can literally get up and walk out the door and say, this isn't for me. And the court is not going to end up setting aside an agreement. And they've said it time and time again. They're not setting aside the agreement because you felt compelled to sign it because your wedding was going to be canceled, or you felt compelled to sign it because the wedding invitations have been sent out. Your family is on a flight to New York to have your wedding, and the flowers are rolling in and you're about to walk down the aisle. It's not enough. You still have a choice of saying, no, I don't want to do it. So duress is really a threat that is different than I'm just not going to marry you.
Right. And that seems to be the case all over the country. That is not just New York. I mean, I can't think of a case off the top of my head where a court has said invalidate the entire prenup because of a time period issue. Like, even California is a state that requires a minimum of 7 days between the finalization of the agreement and the signing. But there are very few states like that. And so it's not just New York that is upholding these agreements.
There are very few states. Look, I'm going to say this. I would prefer, as an attorney, that there was a time period.
Sure.
Because I do think that sometimes people do feel pressure, okay? Different than duress, okay?
Yes.
Pressure to get it done. And very often you're in a heavy negotiation in terms of a prenuptial agreement, and you're being given the prenuptial agreement very close to the wedding date.
Yeah.
And maybe you were even surprised that you're getting this prenuptial agreement. It could be, a week before, it could be 2 weeks before. We see it all the time. And I think that there's a strategy and a tactic to doing that. And people do feel more pressured, but that's not going to be enough to set it aside. So do I wish that there was that there was a specific time period that people actually had to, almost like a cooling off period, that they had to sign it 7 days before? Sure, I do. I also think it would be much more enjoyable for the people who are getting married, okay, not to be actually literally signing the prenup as they're walking down the aisle, because that should be such a happy time. But that isn't the law. And they will not set aside the prenup just for that particular reason. Just as you
Sure.
stated, they're not going to set aside the prenup just because you didn't have an attorney.
Exactly.
And so, we do certain things in our prenuptial agreement. If someone does not have an attorney, we make sure that our client has advised their spouse to be that they should have an attorney. We make sure that that is literally in the agreement. I sometimes have people initial that particular section of it.
Yep.
I think that I put it in various parts, perhaps at the top of the agreement and at the bottom of the agreement, so that people can come back and say that I didn't know that I could have an attorney. Well, you've been advised. It's right in the agreement. You have been advised to get an attorney, and you've determined that you don't want one. That's your choice.
And in this particular case, husband chose not to have an attorney. And I want to just pull that quote. The absence of legal representation without more does not establish overreaching or require an automatic nullification of the agreement. Thus, the defendant husband's position that he was deprived of the advice of independent counsel when negotiating and executing the prenuptial agreement is in a validly executed prenuptial agreement pursuant to the section blah, 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 upon dissolution of the marital property must, okay, I'm not going to continue on. You get the idea. But Judge Sunshine is saying, look, in and of itself, just the mere fact you did not have an attorney is not enough.
Right. I think that, again, there would have to be quite a few different components that go along with that. So perhaps, and I don't remember in this case if they had a schedule of the assets and the liabilities.
They did.
Okay. Well, that in
but
itself.
They didn't include income.
Right. So, and Judge Sunshine dealt with the fact that they didn't include income,
Yeah.
but the fact is he upheld their division of property, and their division of property was kind of interesting, right?
Yes.
Each party got to keep their income, keep all of their assets. Anything that was in their name was theirs. Anything that was in joint names was going to be marital, which meant, by the way, that there might have been very little marital because somebody might choose during the marriage to keep accounts only in their name.
Yep.
And yet, Judge Sunshine said, this is still okay. This is acceptable. I'm not going to overturn it. They were actually fortunate in terms of the prenup that the entire prenup was not overturned,
Yes.
okay, or set aside. And the reason that Judge Sunshine stated so in that case was there was a severability clause. And that, I think, was very important. And I think this goes to attorneys who are drafting prenuptial agreements, and parties who are entering into prenuptial agreements need to read very carefully. And they need to think very thoughtfully about what the components are of their prenuptial agreement. So the severability clause in itself essentially saved the remainder of the prenuptial agreement, because Judge Sunshine said since they had this severability clause, which basically in sum and substance says if one clause is found to be null and void, it doesn't void out the entire agreement. And so even though the spousal support the waiver was found to be null and void, it didn't actually nullify the remainder of the agreement. And he reached back into all of the clauses and looked at the agreement as a whole and upheld a portion of it, a large portion of it, and then as to the spousal support did not uphold their waiver.
Severability clauses are so important. They are in every single prenuptial agreement. But I don't think that the average person entering into a prenup would ever think of that. I don't think they know what a severability clause is. So can you break it down for us?
Sure.
Really simply?
Essentially, in sum and substance, it states, okay, that each clause is going to stand on its own. That just because one clause turns out to be unacceptable to a judge or null and void or against public policy does not necessarily nullify the entire agreement. And so you're going to look at each section essentially as if it's a separate section. And that is very important, because if you don't have that severability clause, or if you do just the opposite, if you say if one clause is null and void against public policy or for some other reason the entire agreement is thrown out, that would be the opposite of that severability clause. So I would say a couple of things. First of all, if you are not represented, okay, you should be reading this very, very carefully.
Yeah.
Because it is a total agreement. And there is that term boilerplate that people often use. And they may say sometimes to us, well, a lot of this is boilerplate. The prenup is boilerplate. A prenuptial agreement is not boilerplate.
No.
Just like this decision that Judge Sunshine wrote is not a boilerplate decision. It is very factual. It is based upon the facts of these two people. So is your prenuptial agreement. Your prenuptial agreement is crafted for the two of you. And it takes a lot of time and a lot of crafting to come up with a plan, essentially, for a prenuptial agreement. And so these are terms that you should be discussing all the way through. But most importantly, you need to read all the way through. You need to read every line in your prenuptial agreement before you sign it. And when you sign it, and you used a word, Julia, just a few minutes ago, you said it was notarized. Okay, great that it's notarized, but it has to be acknowledged in a form actually required to file a deed if you're in New York.
Yes.
If you're in New York State, it must be in those big, nice acknowledgments where a notary then signs after you have signed. It's dated, and it's an acknowledgment the same as you would go off to file a deed for your home. And if that does not happen, then your prenup will not be valid. And so sometimes people come in, as you know, with agreements that have been notarized, not good enough.
Yeah.
And sometimes people come in and they don't have necessarily as Judge Sunshine pointed out, the calculations, right? You know, what's interesting about these calculations that Judge Sunshine actually refers to is when people waive or negotiate for child support, and when you're drafting an agreement for child support, you have very similar calculations that you must put into an agreement. You have to put in all of the calculations that go up to the statutory cap, and then the additional calculations if you're going above the statutory cap because the incomes are higher, and then the reasons for the deviation from the statutory cap if you are deviating from it, which a lot of times people are. Those are all calculations that go into an agreement, and the child support will be set aside if you don't have these components. Same thing for the maintenance, actually, the spousal support waiver that Judge Sunshine is referring to. You must have all the calculations because really, if you think about it, it's not fair to waive out of something if you don't know what you're waiving out of. And that is really what Judge Sunshine has said here. How could you waive something when you don't have any idea what you're waiving? And that is why I think Judge Sunshine made the decision that he did in terms of setting aside essentially the maintenance portion of this particular prenuptial agreement.
I think a lot of that is analogous to the need for or importance of a full financial disclosure.
Without a doubt.
That financial statement is essential. There is a lot of question, I would say, from couples all over around whether or not that financial schedule is necessary. And I think that if the couple in this case had not filled out financial schedules, this decision would be completely different because again, to your point, how can you waive your right to certain assets that you don't know the value of?
Without a doubt. Okay, it is the very first thing that we give to people. After they retain us, they get actually a sheet so that they can fill in their assets and their liabilities, right? And so that they can provide their income to us so that we could do the calculations for spousal support, and also so that we have your assets and your liabilities. And very often people will say, well, I don't necessarily want to reveal my assets or my liabilities. And the answer is you have to. Because if you don't, I agree with you, the Judge Sunshine decision would have been very different. I think he would have set aside the entire agreement had the parties not actually given the information as to assets and liabilities. Because again, there wasn't transparency then. And the prenuptial agreements, as we've discussed so many times, are really about transparency.
Yes.
What are you keeping a secret? You're going to be entering into a marriage together. This is your financial partnership. You need to make sure actually that you have been very transparent about it. Keeping it a secret is not going to work or to help you later. So make sure you actually are very transparent when you're entering into this prenuptial agreement.
Absolutely. I want to go into unconscionability too. This is a really common question. I don't think most attorneys even know how to answer it. And it is a big part of this case. So unconscionability in a prenup will invalidate the entire agreement. Judge Sunshine states that as relevant here, unconscionability is found when a prenup is manifestly unfair given the nature and magnitude of the rights waived and in light of the vast disparity in net worth between the parties. Courts have further held that an agreement might not have been unconscionable when entered into, but may become unconscionable at the time of final judgment would be entered. So explain to us, what does unconscionable actually mean, Lisa?
So essentially, nobody in their right mind would sign it. That's essentially what unconscionable means. And it's interesting because you look not only at the time,
Mm-hmm.
but you're also looking at the time perhaps of the divorce.
Mm-hmm.
Now, what are they really looking for? Usually, if someone is going to become a public charge, meaning they can't be self-supporting in any way, shape, or form, and they literally are going to become supported by the state or the government, then it is going to likely be found to be unconscionable. And so that is the big exception. However, I'm going to go back to this particular agreement because I find it so interesting. There was definitely a disparity here. There was a large disparity here. And again, all the income that was accumulated during the marriage was going to be in somebody's name likely, and that person was going to be able to keep it. And as I remember, the other spouse was not working.
Yes.
And so that person was going to have no income. And so if, as that was the case, somebody was going to be able to save all their income, and somebody was going to be left perhaps with maybe very, very little, okay? Even though there was some clause in there that said if it was in joint names, it would be marital property, both of them would have to decide that it was going to be in joint names. And so that is an agreement that more and more people are entering into in this
Mm-hmm.
time period, where people really want to have control of their own earnings. And we see that in virtually all the prenups that we're doing right now.
Yeah.
Is people are coming to us and they want basically this outline of the Judge Sunshine case.
Yeah.
Everything that I earn is going to be in my name. Everything that you earn is going to be in your name. And we'll have a joint account that essentially we pay the expenses from. And if we decide that we're going to purchase something together and put it in joint names, terrific, that'll become marital property. That was not held to be unconscionable. That was not held to be overreaching. Judge Sunshine upheld that agreement. This was a choice that people made.
And I think this is becoming so common this day and age, not only because of relationship dynamics, but this concept that we at HelloPrenup have been talking a lot about, which is the bank of mom and dad. Right? I think there was just a New York Magazine article that came out, and it was talking about how the bank of mom and dad looks for different couples. And many of those individuals have parents who are significantly contributing to their lives, either financially, either with down payments or mortgage payments, or just, paying for their grandchildren's schooling, private schooling. And so I think especially in a scenario like this, you have to think, well, if you are receiving money from, as we'll call it, the bank of mom and dad, how do you protect that? And a prenuptial agreement is the best way to do that. Do you agree?
Without a doubt, okay? A prenuptial agreement is really important, but it also has to be very thoughtful, right?
Yeah.
So the bank of mom and dad have to be involved in this thought process too. And for the people I think who are listening to this, it's important the mom and dad are listening, and it's important that the people who are getting married are listening. So it's very easy, I think, for the bank of mom and dad to give a down payment for a house, right? That is something that is so common. And the question is that house in joint names? And when they give that particular money, are they giving it to both of them? Is that the intention? Are you giving it to both your daughter and your son-in-law, your son and your daughter-in-law? Is that the intention? And if that's not the intention, then you need to make sure that there was a carve-out in that prenuptial agreement for gifts. And what happens if those gifts go into a asset that is in joint names, or if it's paid directly to both parties, or it goes directly into an escrow account for the house payments, etc. There needs to be a real thoughtful, I would say, policy, okay, of how you're going to deal with this bank of mom and dad. Because there's the issue of what happens later, right? Does everybody just split this house in half essentially, or the equity in half? Or does somebody get a separate property credit? And have you dealt with that separate property credit in the prenuptial agreement? And we do. We deal with the separate property credit, and we deal with the appreciation of that separate property very often in the prenuptial agreement.
And how do you think that parents should be looking at prenuptial agreements if they have children getting married?
So I would say a couple of things. I think that the conversation needs to start very early about prenuptial agreements.
Like
I
how
think
early?
I would say when people are raising their teenagers, they should be having these conversations because it's never too soon to be talking about finances with your kids. That's number one. And number two, it's a real conversation so that it's not a surprise when they meet, the person of their dreams, the love of their life, that they kind of know that if they want to be actually receiving funds from the bank of mom and dad, that they have to have some sort of a prenuptial agreement that addresses that. Because here's the thing about the bank of mom and dad. Mom and dad may have worked very hard for that money. And I say this all the time. And they may not even have an issue with their son-in-law or their daughter-in-law receiving the money. But what happens if there's a death? What happens if their daughter or son actually is deceased? And now everything passes, according to perhaps the prenup, to the son-in-law or the daughter-in-law.
Sure.
And then before you know it, it's not passing down to the grandchildren necessarily. It's passing to somebody
New
else
spouse.
that they're a new spouse, okay, a new family. And so it's really a whole thought process about how to handle this. And that's why you may love your son-in-law or your daughter-in-law. You may think it doesn't matter, I'm good with it, okay? Maybe you are so happy to have them in your lives that you want to make sure that they too are happy and that everything is working well for your children. However, you need to think about what happens if somebody actually is deceased.
Absolutely. I know so many families who just have this blanket policy. Anyone who's getting married gets a prenuptial agreement. I personally, obviously, think that should be the policy across the board. I think everybody getting married should get one because it forces you to have those conversations. And especially for families, I think, it depends on the family dynamic. It depends on the history of communication, but I think it is something that can be really hard to talk about. And if you have a blanket policy and it is set from the very beginning, it is something that your kids grow up knowing is really important to you, it's not going to be a shocker, right? It's not going to be a shocker to the future spouse either, which can lead to family issues.
Yes, and that's the point, right? If your children know that this is basically the policy, right? That there's going to be perhaps inheritance and gifts along the way and contributions and all sorts of, other maybe dynamics in terms of the family, inheritance,
Sure.
trusts, all of that. The conversation needs to be set up early so that these are not surprises, that you're not having this conversation as the invitations are going out. That's the key. So that when they're dating, when they're actually getting serious about somebody, they can say, I just want you to know it's been a long-standing discussion in our household, okay, as I've been growing up, that everybody gets a prenup. And that my brother and my sister got prenups, and that this is what's going to happen. So I don't want you to feel surprised, and I don't want you to feel that this is it's not a personal attack. This is about what my family has talked about because this is our family legacy essentially, and we want to make sure that the family money is going to go to us properly and to our children and my parents' grandchildren and our great-grandchildren, etc. And so that's what this is all about.
My guess is that in this New York case that we're talking about, the conversation was not had early enough. Because if they're signing the prenuptial agreement only 7 days before the wedding, he's unrepresented, I feel like there was probably less communication about the importance of this agreement than there should have been.
I think that's probably true, although I'm going to say
Yes.
that they may have had the conversation for a really long time and then nobody got around to actually getting the draft.
Yes, that is
right?
the other thing that happens.
Right. And so that also could happen. You really want to make sure that you actually are drafting the prenuptial agreement early on. And so going onto HelloPrenup and dealing with those issues, right, and going through the program, or hiring an attorney, retaining attorneys so that you have this done, talking about what terms actually are going to be in the prenuptial agreement so people aren't surprised. That's the key. It's about communication and transparency so that nobody is shocked.
Totally. I think one of the most interesting pieces of this case for me was that husband said he did not know that he needed an attorney. It was something that was kind of brushed off. He didn't. I don't know if it said he didn't have an opportunity to have an attorney, but that was certainly implied from some of the language. And this is one of the reasons that in HelloPrenup we give couples access to attorneys, licensed attorneys in their state from day one, right? So it's so inexpensive, $49, and you can talk to a licensed attorney in your state. $699, and they will represent you. And to me, that removes the argument entirely that I couldn't afford it, I didn't have time, I couldn't find one. It's right in front of your face, and it is very affordable.
100%. I mean, Hello Prenup is a phenomenal service that is offered to couples who want to have prenuptial agreements. And frankly, if they don't have a great deal of money, this is a place that they can come to get their prenuptial agreement.
Yes, access is incredibly important to us. And I do believe that having access to those attorneys at affordable rates in your state removes the argument down the road that you couldn't find an attorney, you couldn't afford an attorney, you didn't have time.
I'll say one more thing. It's okay if your spouse-to-be pays for your attorney,
Yes.
right? So also really important because there may be complexities, et cetera, in the prenuptial agreement, and you may want to have an attorney who is, frankly, very skilled in drafting, very skilled in negotiating, and that's going to be expensive. And the point is that it's okay if your spouse pays for your attorney. And so if you don't have the funds and someone is presenting you with a prenuptial agreement, ask your spouse to pay for the attorney.
Absolutely.
It's okay. It doesn't actually diminish the validity of the agreement.
Absolutely. I don't think many people understand that.
Yeah, I think that is a question that is often asked, right?
Yes.
Somebody will come to me and say, am I permitted to actually pay for my fiance's attorney? Absolutely, you can pay for your fiance's attorney. No question about it.
So, Lisa, for those attorneys who are drafting New York prenuptial agreements or on HelloPrenup editing New York prenups, what should they be including for an alimony waiver specifically? Calculations?
Yes. So specifically, they are going to include all of the factors that one considers in terms of maintenance. If you were going to actually go to court or you were entering into an agreement for a divorce, et cetera. And there are about, I think I counted them last night, there were about 15 factors, right? So you're going to actually literally list all of the factors that the court might consider in terms of an award of spousal support. That way, your spouse-to-be knows what are the considerations. Then you're going to be actually plugging in the income numbers from hopefully the last filed tax returns or the W-2s, whichever one is handy. But I like that last filed tax return because it'll also include any investment income or any losses, et cetera. So you're going to be plugging them into the statutory calculations. You're going to do the statutory calculations based on that $228,000 of total income, and you're going to do it above the cap, the 228 being the cap, and then above the cap. And then and this is my belts and suspenders, I personally think you need to also include the reason for the deviations. So if you're waiving maintenance or you're actually deciding that you're going to pick a different number in terms of maintenance, or you're going to do something different in the agreement where you're maybe in consideration for equitable distribution, you are waiving maintenance, you're going to list those deviations, the financial circumstances of the parties, the other portions of the agreement, et cetera. That's your belts and suspenders. You've now actually, and one last thing, which is you're going to actually also list the components of what makes up the duration of the maintenance. So the years of the marriage. And there is a whole scale of how many years you are married and how many years you could be entitled to maintenance. And then you have covered all the components that I think you need for a true waiver or a true deviation from maintenance. And then you've got your belts and your suspenders. And then obviously make sure that, again, that agreement is notarized in the form that's required to file a deed.
And for those attorneys who are advising clients on whether or not to waive or modify spousal support, how do you look at something like that?
So I look at it various ways. I think that if somebody is insistent upon waivers of spousal support, then you need to look at what are your career opportunities. Right? So this is really such an important piece of negotiation, right? So sometimes I will have one person who is extremely wealthy and the other person who is not. Somebody who literally is not going to have a career, perhaps, or certainly not have a career that is going to be in balance with the other person's career. The question is, are you being compensated? That is one question. And if you're not going to be compensated, or if you're going to literally be supportive of that other person's career, that's going to be your career and your focus, then you need to rethink perhaps early on, what am I going to do to ensure that I am going to be safe and that I am going to actually have money for my retirement, money to invest, etc. Here's the thing, you're getting a heads up in a prenup. Okay? This is your heads up. Doesn't mean that you don't have to get married because you're being asked to waive maintenance. It means this is your call, okay, to action. Okay, you may decide that as part of that call to action that you need to build a career, that you can't be that support system for someone else. And I think you need to be honest about that. You need to say, hey, look, I understand you don't want to pay spousal support in the future, but then I need to focus on my career just as you have either focused on your career in the past or you've inherited a sufficient amount of funds that you're not going to share with me. That's fine. That's your inheritance. That's your separate property. But this is your call to action, and you need to take it seriously. So either you're going to negotiate that point or you're going to use your call to action.
Another overlooked piece of the prenup is often a death clause or estate planning piece. Talk to me a little bit about that.
So you're right. It's actually usually the last thing on someone's minds, right? Because they're going to be getting married. This is the start of their whole lives.
Mm-hmm.
They're not thinking about what is going to happen if one of the parties actually is deceased. But it's very often, and it's usually towards the end of the prenuptial agreement. So remember we talked about this issue of boilerplate,
Yes.
right? Okay, again, this isn't boilerplate, folks. This is the real stuff. What's going to happen if your spouse actually is deceased? Where are the investment accounts going? Where is the home going? Where are the finances going in the event of someone being deceased? And it's a super important clause. So first part of it is you might be familiar with what's called the right of election. So in New York, you would get automatically, if there's no will or if somebody tried to cut you out of the will and there was no prenuptial agreement dealing with this, you would automatically get 1/3 of the estate. That would include your spouse's separate property also. So you have to think about that. Is that separate property going to actually, a portion of it going to pass to your spouse? Do you want that to happen? What happens if I waive that 1/3 share? You may get nothing. It may be that you say that the wills will control, but you don't really know what the wills are going to be. So are you going to draft them simultaneously? Are we going to attach them? Are we going to say that the will must provide for X? Or are we going to leave it all to chance?
Sure.
These are all questions, and it's usually about 4 or 5 paragraphs in your prenuptial agreement, but they are very serious paragraphs. Or is the separate property passing to your spouse in the event of a child? Is the separate property going to pass to the spouse? Maybe you want your spouse to stay in the marital home in the event of your death because you have children. So there might be clauses that say what happens in the event that there are no children, and there might be clauses that say what happens in the event of children. And it's possible that there are certain trusts that are going to be set up also to tie it up really nicely with a nice bow on it. So these are all really important clauses that people often overlook speaking about, and then we get to the end of the whole prenuptial agreement negotiation and, oh yes, we have to deal with this now. And so
Absolutely.
It's really an important piece.
I would say alimony is probably, or spousal support is probably one of those areas that people talk about more.
Yes.
And then when it comes to a death clause or estate planning, it kind of feels like an afterthought.
It almost is the afterthought, right? I mean, part of our consultation, we definitely speak about it, but I think generally for people, it's an afterthought because, again, they're at this exciting time. They just got engaged, or they just, they're planning their wedding. They're not thinking about what's going to happen if someone is actually dying. And so this is super important. The other piece is insurance, life insurance. Is there going to be life insurance that you might want to put into a prenuptial agreement so that someone is covered, particularly if there's going to be children, or particularly if there's going to be a less moneyed spouse, and perhaps you decide that you're going to waive you're going to waive that 1/3 election, but you decide you want life insurance instead as part of your negotiation, and that your spouse is going to actually carry that life insurance so that you are covered. So lots of different ways to negotiate this and deal with it, but it has to be part of the discussion.
How do you think this conversation differs from if you are entering into a first marriage versus a second or third marriage?
So it shouldn't differ. Okay, but it does, because again, I think people, when they're entering into their first marriage, they're often younger. They're not going to be thinking about,
Starry-eyed.
right, and they're not thinking that, I'm going to have all of these health issues and I might be in this situation. Some people do, but it's not as often that people are focused on this particular issue. However, I think that if they're thinking about having children, they often are thinking about this estate and trust clause.
I think especially for second marriages, if you
Yes.
have children from a prior marriage, I think you have a duty to protect the money that is intended for those children.
Well, that's the question. Do you? Okay. This is the question.
It's
whether
it's
you
more of a moral
do or
question than it
not,
is, yeah.
Okay. And the question is, does your actual divorce agreement require you to
Yes.
actually protect for those children?
Yes.
Or perhaps you feel like you've given enough and you want to make sure that you are setting up a new family or a new life. And that is something that is your choice, because this may have been money that you did get in your divorce settlement. And perhaps there was enough equitable distribution. There were enough trusts with money set aside for those children. Enough college was paid for, and medical school and law school and
Yep.
all of that. And so, but it's a great question. And in many divorce agreements, there is a negotiation about this particular issue. I will tell you, it's a hot issue, because people want to be able to do what they want with their property after their divorce.
I've seen that in plenty of divorce agreements where, I mean, it outlines that certain assets must be protected with a prenuptial agreement if that party is to get remarried.
And it's really super important that people remember that
Yes.
when they are actually negotiating their prenuptial agreement, to let their attorney know that that exists, that clause exists in their actual divorce agreement.
So if you have a client who has been divorced and is getting remarried, you didn't do their divorce, you are doing their prenuptial agreement, do you go back and look at that divorce agreement?
I might not, frankly. They may decide that they don't want to be showing it.
Yeah.
Perhaps they are not interested in even looking at it themselves, because they may literally be going from one marriage to
Yeah.
another marriage.
Yeah.
But I do ask, is there a clause in your divorce agreement? So sometimes we see it, sometimes we do not see it. It depends. And so it's really something that's important that you speak to your attorney about.
I have a hot take, Lisa. I'm convinced that men get remarried faster than women. What do you think?
I think that's probably true. I think that is probably true. It's interesting. I have a lot of female clients who really have no interest in getting remarried.
Yeah.
They have now gotten control of their finances. They have decided that they actually can be independent, and they have gone through all of this process in terms of divorce, and they want to actually now have their lives to themselves. And so I think that that's true. I don't see that as much with my male clients.
Yeah. I
think
hear the
that's
same
true.
thing. Yeah. It's
Yeah.
anecdotal. I don't have any data on that.
Yeah,
But
same.
from an attorney's perspective, Lisa, what are the most controversial clauses that can be included in a prenup?
So I would say, from my perspective as an attorney, one of the clauses that I often see and I find very controversial is a waiver of legal fees and expert fees in the future. So you may have issues such as child support and custody, which normally are not covered in a prenuptial agreement unless the child is born, right? And we've discussed this before, Julia. And so because of that, you may need actually to hire an attorney. You may need certain experts, such as forensics, child psychology experts, such as other experts in terms of a custody case or a child support case. Perhaps you're going to even need forensic accounting firms figure out what somebody's income is, what the lifestyle was in terms of child support, all of these types of issues. And frankly, in New York, this is all really expensive. And so I often see these clauses that say each party in the event of a divorce is going to actually pay for their own legal and expert fees. Well, that could actually really be a terrible situation for somebody, really wipe them out in terms of being able to litigate custody and child support issues, to make it absolutely impossible for them to do so. It also is, and there are cases out there, against public policy in many cases. And so sometimes what they do is they put, I think just, it's generous, and there's a clause that says I'll pay $100,000 or $200,000, but the litigation could cost much more than this. And so
Absolutely.
they've tried to cover themselves in terms of public policy issues, and perhaps some judge actually does feel like that would be sufficient, and now somebody is out litigating you and truly grinding you, and you cannot keep up with it, and all of a sudden your custody is in jeopardy of your child, or your child support is in jeopardy, and you have actually made that waiver. And so you have to be super careful about those particular waivers. It doesn't feel like it's that important now when you're signing your prenuptial agreement, but trust me, it's going to feel really important later if you are litigating those two particular issues.
Do you see those clauses being upheld?
So I have seen them set aside where there is zero being given. We have definitely litigated that issue several times, and the judges actually have awarded legal fees and expert fees despite those clauses. However, I think the trickier part is when you actually are given an amount, as opposed to being as opposed to the prenuptial agreement saying that there is no money for being given for this particular purpose of expert fees or legal fees. And I have not litigated that particular issue yet.
Okay.
So I don't know if that clause would be set aside or not. If there was significant monies being given for legal fees, but maybe not significant enough.
What other clauses have you seen that are just like, be warned, this can have a really negative impact on your future?
So I think that the clauses where, and trust me, we draft these agreements. So I think you have to be super careful about the clauses that say that everything is going to be separate property that's going to be in somebody's name. And yours as well, right? Everything that you earn will be in your name. Everything that your spouse earns will be in their name and will be their separate property. You have to calculate, well, what does that mean for me, for my future? And as I said earlier, this is a heads up. This is like, your action call, right? Mm-hmm. That you have to think, yes, I understand that they come into the marriage perhaps with a lot of wealth, and I don't come into the marriage with as much wealth or maybe any wealth, and they want to keep that wealth for themselves, and I understand that, and that is their separate property, and perhaps they never have to work in the future at all because they have such significant wealth. But then again, you have to watch out for that clause, because you could be married 20, 25, 30 years, and if you haven't worked and if you haven't received inheritances that are significant, you could be in a situation where it is dire at that point. Perhaps you're not going to be a public charge, but what if you aren't a public charge and you have so little that you can barely get by, and you had created an entire lifestyle with this other person? You need to watch out for these clauses. And again, it may be that you decide that you're going to sign the prenuptial agreement despite these clauses, but then you have to decide, what am I going to do to plan for my future? So I think that's really important.
I think so many women end up in this situation. I mean, I have friends who signed a prenuptial agreement not through HelloPrenup. They went the traditional attorney route before HelloPrenup existed. And they ended up in a really tough spot upon a divorce. And this one particular one that I'm thinking of, her husband had a lot of wealth, hundreds of millions of dollars. And effectively, in the divorce, she got a couple $100,000. Now, she didn't work during the course of the marriage. It was a short-term marriage, but she supported him in his career. She flew all over the place with him. She was the one who hosted the parties at the house, planned the parties, did all the coordination, and effectively feels like she's walking out with nothing. I mean, to the point where she doesn't even have the right to take some of the gifts that he gave her that are significant in value. But I think it's really upsetting to her. And again, this is not one individual. This is many different stories combined. Um, and I just wonder if you have any advice for women if they're in that position where they are marrying someone with really significant wealth. What should they be thinking about? How should they be looking at this prenup to ensure that they are also protected?
So it's such a great question because I see it basically every week.
Yeah.
We see this. Negotiate hard. I'm going to say that. I've said it before. You and I have spoken about this. Negotiate hard and don't be so afraid to negotiate.
Yeah.
I think that is the problem. People feel that he or she is going to walk away. Well, perhaps he or she will walk away. Okay, that is a possibility. But perhaps they will step up to the plate and be more generous. But if you don't negotiate and frankly negotiate in a way that is significant, that you really mean it, that you are willing to walk out the door, then you really won't know what your self-worth is going to be worth to that person. What will they actually put into that prenuptial agreement that you thought wasn't possible? And so I think you have to think about that. If there's such a lack of generosity, if there is an expectation, and to your point of of these people that you're talking about, that you're going to fly all over the world, that you're going to be there to
Host the
parties and socialize and be there to be supportive and to be fun and to do all of those things and to have this great life together. But at the end of the day, you actually have no assets. What is that going to look like for you? And that is not a good prenup to be entering into. And those are very often the prenuptial agreements that we get just weeks before. And we are begging, frankly, our clients, pleading with them not to sign those particular agreements. And yet, many times they decide that that's what they want to do. And look, we see the other side of it when people come in and they are actually getting divorced and somebody has negotiated those types of prenuptial agreements and they willingly signed them and they knew what they were getting into and they want to know if those prenuptial agreements can be set aside. And there it is, beautifully acknowledged in the form required to file a deed with a lawyer who on each side who reviewed it and all of the bells and whistles. And the answer is no, that's what you negotiated. And so you need to be thoughtful about what you are willing to actually bear, essentially, in your life. And again, it doesn't mean you don't have to sign it. You can sign it, but you need to plan then. What's the action plan? It's so important.
I want to talk to you about interorum clauses. Are you familiar with them?
I am. So it's an interesting thing about these particular clauses. So this is where someone actually has a clause that if somebody moves to set aside the agreement, first of all, you might not get anything that's in the agreement that you actually wanted. Okay, so that's actually part of it. Or you may pay the legal or expert fees actually to defend the action where you move to set aside the agreement.
And this can even be the less moneyed spouse. I just want to clarify.
Without a doubt.
Yeah.
It is almost always, of course, the
Yeah.
less moneyed spouse who now is moving to set aside this prenuptial agreement and who feels that it is likely unfair in some way. And it's very important that you are looking at these clauses. This goes back to my same issue about the issue of legal fees and expert fees waiving. These are clauses that are put into these agreements, and they often are just glazed over when you read them, right? They are not boilerplate. I again say they are not boilerplate. You must read them and read them with a critical thinking mind so that you can say to yourself, well, what's going to happen if I need to set aside this prenuptial agreement? First of all, should I be entering into this prenuptial agreement if I'm concerned about setting it aside? Mm-hmm. And then second of all, have I actually thought about the fact that if I move to set it aside, that I might end up paying legal and expert fees, or I might actually lose my maintenance, or I might lose some other, item that's in the prenuptial agreement, some other provision that was actually good for me. And so it's really important to do that. We often put this clause into the agreements because we want to make sure that people understand that these prenuptial agreements they are the Bible. They are going to be the contract. They are it. And so you are signing up for this prenuptial agreement. It is not something that you are going to be able to cast aside when you don't like it anymore. It is not something that you're going to be able to set aside, which is the words that we utilize in the prenuptial agreement. It is going to have strong ramifications. It's a contractual partnership agreement with your future spouse, and it's all about the finances. So you better actually read.
And this goes back to your concept of you need enough time. If you're going to be negotiating hard or negotiating at all or reading all of the words on the page, you need time. You can't be doing this a week before your wedding, 2 weeks before your wedding. Many people do, right? And maybe they take that time and they're really focused on it. But I think having enough time gives you the opportunity to really consider the clauses, the opportunity to consult with an attorney, the opportunity to go back to your spouse or future spouse and say, I need a little bit more clarity on why this is important to you, and have those life planning discussions.
Yes, and I think you also need to see, is there flexibility on the other party's part? Perhaps there isn't. Sometimes there's no flexibility. Perhaps, as we talked about earlier, this is legacy money, essentially, and there's very little flexibility. Perhaps a brother, sister, cousin have all signed these prenuptial agreements because that is how they're protecting their family wealth for the long haul, for grandchildren and great-grandchildren, etc. And so, again, it's really important that you read it, that you think about it, that you make sure that you are willing to buy into this.
So for couples who are planning to have kids, there is a clause in the prenup around vacating the home in the event of a divorce. Can you talk to us a little bit about that?
Sure. So we do usually our prenuptial agreement will have a very involved clause in terms of what happens to the marital residence. So either someone is going to automatically have a first option, and then the person will have a second option perhaps. Maybe we've decided that the marital home will just actually be sold at the time of the termination event. Perhaps there's going to be appraisals actually that are going to be conducted. So there might be a first appraiser, and then somebody has the option to get a second appraiser. And then if they're within 10% of each other, then we actually take the average of the value. There's lots of different ways that we do it. If we're selling the marital home, we also have provisions of what's going to happen in terms of the sale. So we find that appraised value. We agree upon what it is. How we agree upon it is set forth in great detail in the prenuptial agreement. And then once we have it, there may be price lowering mechanisms actually in order to sell the home. So maybe after 60 days or 90 days, the house or the apartment is actually, the price is lowered by, a certain percentage, 3%, 5%. And then within a certain amount of a percentage, they need to take the offer if it's a bona fide offer. So that's part of the prenuptial agreement that we usually do. Then, of course, there is the issue, well, what happens if somebody actually wants to keep the home and there are children, to your point?
Yes.
And the question is, well, sometimes there are clauses in prenuptial agreements where somebody else has to vacate the home, perhaps within 60 days of a termination event, 90 days, whatever it is. But if there are children and there is no custody agreement, then essentially that person may be prejudiced in a certain way by vacating the marital home, because the children are likely to be still in the marital home, and you may not have sufficient time to negotiate a custody arrangement or to get into court if it's necessary to deal with a custody arrangement. So we usually put in a clause that speaks to this particular issue, something like in the event that there are children of the marriage, that neither party will need to vacate the home prior to the earlier to occur of a temporary custody arrangement being placed in writing in an agreement, or a permanent custody arrangement.
That's really helpful.
Yeah, because otherwise somebody is going to be prejudiced. And I have seen this, I think the reason why it's so important that people have experience when they're actually drafting these agreements is that you see so much when you're litigating cases of what happens when the prenuptial agreement was not thoughtful. Okay.
Yes.
And so I did have a situation many years ago where the clause actually was that somebody had to vacate within a certain amount of days from the residence. And that person would have been totally prejudiced if they had to do so, because their children wouldn't have actually vacated.
Right.
And their children were older. Their children didn't want to probably vacate. They wanted to stay in their rooms,
Right.
which is often the situation, right? And so the bottom line is that that person wouldn't vacate. Well, then we were saying, well, then you're in default. Right. And so now the person is in default, but they don't want to vacate because they don't want to prejudice their rights to custody of their children. And it becomes a spiraling situation. So it's important that it be thought out by both parties and that the language be appropriate for both parties so that you don't end up in endless litigation over things that could have been prevented.
Absolutely. Absolutely. And in your experience, do you see prenuptial agreements preventing litigation?
For the most part, yes, without a doubt. I think that for the most part, prenuptial agreements will prevent most litigation. However, they have to be thoughtfully written because there are also times when they are not thoughtfully written and then there is litigation. And
Absolutely.
you do not want to have that situation because the whole point of a prenuptial agreement is to make sure that everything is thought out, that all of the T's are crossed and the I's dotted so that you end up in no litigation or perhaps litigation over items such as child support and custody, which you couldn't have actually dealt with in a prenuptial agreement. But it really does. I think it saves us so much in terms of fees for people. Yes, you're spending some money to get your prenuptial agreement done, but it's so important.
And
It's
I
so
think it
important.
also starts the marriage off on the right foot. I mean,
Yes.
hopefully you never have to use it. Hopefully litigation and divorce is not even part of the conversation because you've had all of these really important life, transparency, planning discussions before you even get married.
Yes, but I'm going to say this. Every once in a while, people should dust off their prenuptial agreements and read them. Okay, because I can't tell you how many people actually end up in litigation, and the sole reason that they ended up in litigation is because they didn't follow the prenuptial agreement that they had spent so much time and effort actually negotiating. And they did the opposite of what the prenuptial agreement was meant to actually do. So you really do need to actually read the prenuptial agreement. You also need to make sure it's kept safe. Because, I very early on when I first started practicing law, one of the very first issues that came up was the prenuptial agreement for the client that came to me was done, 30 years before, and she couldn't find her copy.
Oh, no.
And she swore up and down that the prenuptial agreement gave her 50-50 of all the assets. And of course, the husband swore up and down that there was no prenuptial agreement, that it
Oh,
was
no.
all in her mind, and that there was no 50-50 arrangement, and that all of this money that she claimed was 50-50 was his separate property. And she could describe to a T where that prenuptial agreement had been up until the time that there was a filing, and then it
Sounds
was
like
gone.
it was intentionally misplaced by one of the parties.
Intentionally.
If you have a prenuptial agreement, at what point in your marriage should you be considering modifying some of the terms in which would then make it a postnup in most states?
Right. So as we know, some states actually don't uphold postnuptial agreements.
Yeah.
New York does uphold postnuptial agreements. Again, needed to be actually in the same form as required to file a deed. So make sure you do that. But essentially, I would say when there are children, when perhaps one of you has changed, your employment opportunities. So perhaps somebody is retiring. Perhaps all of a sudden there is a large savings that has taken place that was unexpected. Maybe a company is being sold that one of you owns. All of those kinds of transitions and changes. Maybe there's a health condition that actually has occurred. And we talked about this earlier. Maybe it's a serious health condition. Perhaps there's an issue of the fact that you expected to have children, you expected that there would be a stay-at-home parent, and now everybody is working and you want to change it up as well. So I think transitions, changes, substantial changes, I think it's a good time to actually think about entering into a postnuptial agreement.
And just to over-clarify, in New York, postnuptial agreements are upheld.
Yes, they are definitely upheld as long as you follow the rules. There needs to be consideration for postnuptial agreements. So unlike prenuptial agreements where there's really the consideration is the marriage, there needs to be consideration in postnuptial agreements. What are you giving and what are you getting? And that doesn't mean it has to be equal, by the way. It just means it has to be thoughtful again.
In the form of usually financials,
Yes,
right?
yes.
All right, Lisa. Well, this was so much fun. I thank you for coming on again, and I'm sure you'll be back soon.
I thought it was great. We had a blast, Julia, and so thankful for all of this information that gets out to so many people through your podcasts. Your podcasts are amazing.
Thank you so much.
Thank you.